Hello everyone. Today I am going to dictate you the passage number 16 of the modern volume first. 5 seconds to go. Sir, I move that the bill further to amend the Telecom Regulatory Authority of India Act 1997 as passed by Lok Sabha be taken into consideration. Sir, first of all, allow me to read Article 123(2) of the Constitution. It says that an ordinance promulgated under this article shall have the same force and effect as an act of Parliament. Therefore, an ordinance has the same value as an act of Parliament. Sir, there are many regulatory bodies in India. In the Telecom Regulatory Authority of India Act 1997, we are just making one short amendment to Section 5, which inter alia stated that the chairman shall be ineligible for any government appointment. But very surprisingly, sir, the same provision incorporated that after 1 year he could be eligible for a commercial employment. Therefore, he could never come in government appointment but could be eligible for that. Sir, in India we have got many regulatory bodies. We have got the Insurance Regulatory and Development Authority of India Act 1999, where under Section 8 the chairperson of that regulatory body can be eligible for employment after 2 years. We have got Pension Fund Regulatory and Development Authority of India Act 2013, where again under Section 7 after 2 years he becomes eligible for employment. We have got Airports Economic Regulatory Authority of India Act 2008, where the chairperson can become eligible to work under the government after 2 years. We have got the Competitions Act, we have got the SEBI Act, we have got the Central Information Commissioner. Sir, in the Constitution also, which I was examining under Article 324, Chief Election Commissioner and election commissioners are to be appointed. There is an act governing terms and conditions of their working. Even in the case of Chief Election Commissioner and election commissioners, there is no bar restraining them from not to be appointed in the government after they demit office. There is no such bar even in the case of Supreme Court and High Court judges. The bar is only in the case of CAG and members of the Public Service Commission. Therefore, sir, this particular ordinance is not individual specific. It only seeks to change the palpable anomaly which is existed in the case of TRAI Act and about 6, 7 or 8 other regulatory bodies in which there is no such prohibition at all of long ban. Sir, I rise to oppose the amendment that has been tabled. I do so for 3 reasons. 1. I object to the adoption of the ordinance route. 2. I believe the amendment as moved now is violative of Article 14 of the Constitution. And 3. I believe the Prime Minister had many options other than going against the established law to secure the services of the competent Principal Secretary. With your permission, Mr. Deputy Chairman, I would like to elaborate these three reasons within the limited time that I have. First and foremost, there were no emergent or urgent conditions warranting the issue of an ordinance. All the arguments that have been placed before us by the Honorable Law Minister, who is also the Minister of Communications, do not indicate that there would have been a disaster that would have overtaken the country if on that day on which the ordinance was issued there was no equality between chairmen of various regulatory commissions. Indeed, sir, it is ironic that this provision was brought in by the NDA government. They brought in the provision, they remained in power. When they were in the opposition, they did not attempt to have it changed. And suddenly, without any emergent need, without any urgent need, they issued an ordinance. Our objection is not in principle to the issue of ordinances, but the ordinance has to be issued in conformity with the provisions of the Constitution, the spirit of the Constitution, and the judgments of the Supreme Court. In all these respects, I am afraid the ordinance move was not in conformity with these conditions that I have said. Sir, Article 1231 of the Constitution requires that it has to be established that there are certain circumstances which render it necessary to take immediate action. What were these circumstances? Why had the action to be immediate? What disaster would have overtaken us if a provision of the law that had existed for a decade or more had been allowed to remain for another few days? It is clearly not the case that there were any circumstances which rendered it necessary to take immediate action when this particular ordinance was promulgated. Sir, even if the Prime Minister, for reasons best known to him, wanted one and only one official to be his principal secretary, surely temporary arrangements could have been made. Thank you.